we have a bit of an Alec Murdaugh break this week, we wanted to talk about something really important that is expected to happen the week after Alec's evidentiary hearing, and that is judicial elections.
So, becoming a South Carolina judge means having to schmooze a lot of people along the way, including members of their local bar associations as well as the state bar. There are also rules that everyone has to follow to, quote-unquote, prevent favoritism. And there's a half-hearted attempt by the members of the Judicial Merit Selection Commission to maintain the appearance of an open-minded process, but everyone knows that the decisions are often made long before the candidates have even appeared for their interviews.
We've reported before on a lot of the elements of this corrupted justice system, all with roots firmly planted by the judicial selection process. We've told you about the Carmen Mullen issues. We have told you about Gerard Price and State Senator Todd Rutherford's ability to secure secret early releases for his imprisoned clients. And we've told you about Bowen Turner, the Orangeburg County teen who was accused of raping 3 teenage girls in 3 counties between 2018 and 2019. For a refresher on the Bowen Turner case, we suggest listening to the Bowen Turner playlist on the Lunashark website. The Bowen Turner case is one of the most telling cases beyond the Murdaughs. It's a case that has exposed so many facets of a system that basically allows wealthy defendants to purchase their way out of accountability. Senator Brad Hutto, who was able to secure a plea deal that included a suspended sentence with probation. And soon after, Bowen, some would say predictably, ended up violating that deal. And that is how he ended up behind bars for less than 2 years. Bowen's case put a much-needed spotlight on several things. One, it exposed the bullying that his victims experienced at the hands of Bowen's friends and their parents. Bullying that was so severe that it led to the death of one of his victims, Dallas Dollar. His case also further exposed the power that legislator lawyers have over those wanting to become judges in South Carolina.
This example shows you how murky of a qualification temperament is. It's a qualification that's widely open to interpretation and one that can easily be used to bully a judge who isn't ruling the way someone powerful wanted her to. So, if a lawyer doesn't like a judge's decision, they can just complain about that judge's temperament come their next election. And if the commission wants to remind that judge of its power, they can make an issue out of it, or they can choose to ignore it altogether. In David Miller's case, temperament, in addition to a lot of issues that we'll get into in a second, came up in November 2023. This next excerpt has been edited for brevity. The part we cut out pertained to him believing that the number of friends he has is a testament to his ability to make sure he does not offend anyone.
I am aware that I am, I'm certainly passionate about the positions that I take in the courtroom. I do think it's fair to point out in that regard that there are times whenever, because of my position as the end of the line before you get to the solicitor making decisions, that there's going to be disagreements about cases. There's going to be disagreements about what needs to be done. And I know that there are a lot of times when I'm really trying hard to find some kind of reasonable compromise and working to try to find some way to help a lawyer with their client, or to help a victim get some kind of relief that maybe the circumstances don't necessarily normally look like that. And sometimes you just got to draw the line in the sand, and that can be interpreted poorly. So I try to make sure that that doesn't carry on. Obviously, though, on the bench, you're not an advocate. You're not an advocate for either side. And so that is one of the reasons why I feel like I would have a better control over anything that was going on in front of me. I mean, I'm not advocating for either side in that position. Whereas as a deputy solicitor, I have to advocate for the state.
His response was basically, I'm passionate about what I do, and my job is hard, and therefore people are misinterpreting my steadfast loyalty as an advocate for the state as me having a temper issue. Now, this is important. Miller's demeanor was brought up to the commission not only by comments that were sent in, but by in-person testimony from Carl Stoller, the father of Dallas Stoller, who was one of Bowen Turner's victims.
Good afternoon. My name is Carl Stoller. I came to speak to you today as a parent of a victim, one Dallas Stoller, and also as a law enforcement officer in this state. In my capacity in law enforcement, I've had the privilege of dealing with many fine judges, solicitors, and even attorneys on the defense side. But I've never quite had the occasion to deal with someone quite like Mr. Miller. What I experienced as a parent of a victim was someone who I would bring his character into question after dealing with him, his demeanor, and his general lackadaisical attitude towards that case. And what I mean by that is I never met the man, okay? I talked to him one time on the of us. And again, as a law enforcement officer, I've never experienced.
And for some reason, Carl's microphone cut out in the middle of his initial testimony to the commission. So we've had to rely on the transcript of the hearing to know what he told them during that part. Here's David Moses with what Carl said happened with David Miller.
He stated during that Zoom meeting he was somewhat apologetic initially. But he said, in light of Dallas's death, they had decided to dismiss the charges against Mr. Turner regarding Dallas's case. That did not come as a complete surprise to me because I do know it's very difficult to prosecute a case without a victim. I get that. Even more so when the victim's deceased. I understand that too. However, it's just the matter of fact approach to it. And I do know as an officer that you can prosecute some cases without the cooperation of the victim. I've done it on assault and battery cases myself in magistrate court. I'm not a prosecutor, so I don't do it on a general sessions court level, but obviously, law enforcement generally in the misdemeanor level cases does their own prosecution in those summary courts. And I didn't have the cooperation of a victim. Some I was successful with, some I wasn't. But to my point, I questioned him and I asked him, I said, do you think that you actually did the best job you could for not just my daughter, but all these victims involved? And his response, he fired back at me. He was angry that I even asked that. He said, I absolutely do. He said, as a matter of fact, I'm going to tell you this. And a SLED agent witnessed this conversation. Our attorney, other people on the Zoom call, a lady from the Attorney General's office. He said, I'm not wasting my time or 12 jurors' time on a case I can't win. Is that the kind of person that we want as a circuit judge in South Carolina?
As a part of her complaint, Sarah Ford filed a 404-page exhibit of email exchanges and court filings in the Bowen Turner case between 2019 and 2023. The emails fill in the blanks of a storyline we are all too familiar with: an aggressive and powerful state senator calling the shots in our justice system. And Brad Hutto, by the way, isn't just a state senator. He is a powerhouse. He has been in the state Senate since 1996 and is currently the Senate Minority Leader. Now, Bowen was first arrested a few months after Dallas's assault in January 2019. But remember, Bowen was accused of raping a teenage girl in April 2018, 6 months before Dallas's assault. But still, in early 2019, Judge McFadden did not consider Bowen to be a danger to society, and he released him on a $10,000 bond. 41 days after Judge McFadden released Turner in early June 2019, Bowen assaulted Chloe Bess, his third high school victim in a third South Carolina county. Bowen Turner was initially denied bond and temporarily sent to the Department of Juvenile Justice until Senator Brad Hutto entered the picture as Bowen's new attorney and demanded another bond hearing where he, Mr. Champion of Women's Rights slut-shamed Chloe Bess and claimed to the court that Chloe's rape was simply consensual sex that she was not proud of after. I will never forget this quote, and I have to say it again. From Brad Hutto. Well, guess what? You had sex on the ground with a boy you didn't know, and you got up and you feel ashamed. You feel regret. That's not rape. I had to quote that again because, oh my God, a state senator who claims to fight for women actually said those words to a teenage girl and never apologized for them. Bowen then got out on a $100,000 bond and supposedly a strict ankle monitor situation, which wasn't strict at all. For the next 2 years, Brad Hutto, as state senators do, managed to stall and delay any progress with the case, and David Miller made it easy for him. In 2019, Sarah Ford kept pushing for a preliminary hearing, but David Miller and Brad Hutto stalled and stalled, and they never ended up having one. Brad mentioned in an email that he didn't want any more publicity on the case, and that was in 2019. That preliminary hearing would have likely been validating for Dallas and for Chloe, who were both being harassed, maligned, and attacked for reporting their assaults to the police. It would have been the first time a prosecutor would present to the public some of the evidence against Bowen Turner. Dallas and Chloe never got that validation, though. They just got a lot of silence. It was heartbreaking to read the emails about Dallas in 2020, knowing the level of pain she was enduring at the time and how much it would have meant to her to have a prosecutor care about her case. After several emails back in July 2020, David Miller agreed to meet with Dallas in August 2020 via Zoom. Sarah Ford attended that meeting and said Dallas could tell that there was no sense of urgency on David Miller's part, and that really weighed on her. In late 2020, Sarah Ford, who again is representing the victims, started to get understandably pesky on behalf of her clients. Here is David reading the email from Sarah.
Hi, David. I know SLED has given you the case file on this matter, and it is my understanding that we are waiting on a decision on whether your office will prosecute. Please let me know your time frame for this decision, as the family is understandably anxious awaiting this decision. I appreciate your time, attention, and consideration to this matter. Best, Sarah.
In November 2020, Sarah sent the following email to Miller.
Crickets? If it's being prosecuted or not, the family deserves to know. Let's meet either way and get it done. Thursday at 3 p.m.? That works well for me.
Miller responded,
No decision has been made about prosecuting the case. There is no reason for any meeting until a decision is made. You will be informed as soon as that happens.
Then Sarah responded,
Well, the one good thing is you were just ignoring the emails and you haven't fallen ill with COVID, David. The bad thing is this family requested this investigation be reopened back in August 2019 after somewhat questionable reasons encouraging them not to proceed. SLED wrapped in June of 2020, and this is November 10, 2020. We're coming up on 3 years since the incident date. This family isn't looking for a crystal 3-year anniversary platter. They're looking for justice for their daughter. And you're the only man they can look to try to get that, David. I've done everything I can to explain how things take time and investigations are slow and there's always delays and I've been in David's shoes and yada, yada, yada. And at this point, I barely believe it myself. These are good people who have been more than patient, who have placed their trust in the system, and they're understandably about to crawl out of their skin and want to give up. But their main focus is on justice for their child. Please give them the respect and courtesy of fully considering this case and prosecuting this matter.
Can I just say thank God for Sarah Ford, one of the few people in this system who actually gives a damn about victims, and it shows. In the emails, I noticed how eager David Miller was to accommodate Brad Hutto's needs. He responded quickly and granted his random request for Bowen to get permission to leave his house arrest for different scenarios. And on March 25th, 2022, David Miller filed a motion to revoke Turner's bond due to his many violations. That same day, Miller sent the motion to Hutto that stated they have asked for a hearing on the bond revocation to be scheduled on April 4th, 2022, in front of Judge Markley Dennis, after apparently multiple judges recused themselves from the case, which is also odd. That same day, by the way, David Miller filed a motion to compel production of a DNA sample from Turner. The motion stated that in 2019, Bowen's DNA was ID'd by SLED as a match to the DNA profile from semen submitted after Chloe Bess's assault. So if they needed more DNA, why wasn't that gathered earlier? It's like in March 2022, David Miller suddenly realized that he needed to start collecting proper evidence for a sexual assault case that took place 3 years before. Well, after March 25th, David Miller seemed to flip from the side of justice and the side of victims to the side of a powerful lawyer lawmaker representing a thrice-accused rapist. It was clear in his March 30th email to Sarah Ford that things changed.
Brad Hutto contacted me and indicated he would like to try to get the case completely resolved instead of hearing the motion to revoke. He has some conflict with Monday, but we would need time to meet with the Bess family to discuss any potential plea, and wouldn't be able to do that by then anyway. So we are aiming to get on the schedule in Orangeburg Friday, April 8th. Obviously, we would also like to meet with the Stoller family before then as well. On that Friday, we will either have the motion heard or Turner would be entering a guilty plea.
Sarah Ford replied politely, "Thanks for the update. Would the plea be in both cases?" Before then, apparently Miller hadn't mentioned anything about dropping Dallas's case. Miller emailed her back with his reasoning.
There will not be a plea in the Stoller case. Without Dallas to testify, we cannot ethically pursue a conviction, and I do not believe that Brad Hutto can ethically plead his client to a charge regarding any assault on her. As such, any offer will be on the Bess case alone.
The problem we have with David Miller when it comes to his fitness for judgeship is this. For 3 years, he dropped the ball on the Bowen Turner case over and over again. He kicked the can so far down the road that one of the victims eventually lost her life waiting for the system to save her. His inactions made the victims feel hopeless, and that hopelessness led to Dallas losing her own life. Dallas's death should have been a wake-up call for Miller. He should have vowed to fight for Chloe and for Dallas and for all the victims of sexual assault. He should have vowed to do what he could so that victims no longer feel defeated by the system. David Miller fundamentally overlooked his duty to serve the people in favor of serving the defense. Likely, he did this because he wanted a judgeship. That was the problem. But that wasn't the problem that the JMSC focused on when they held a hearing in November to allegedly screen Miller to see if he was qualified for a judgeship. They didn't focus on that because how could they? Focusing on that problem would be dangerous for them. It's just the same thing over and over again. Politicians out for themselves and their own enrichment in every possible way, while victims suffer for it. Carl and Sarah went to that hearing in good faith. They did the hard work of trying to change a system that treated them as mere nuances. Worse, they treated Carl the way they would treat a baby at a political rally, using him as a prop so they could express their condolences and seem caring and bothered in the moment. But like Carl said about victim impact statements, the decision was already made.
We were allowed to give a victim's impact statement to the judge at that hearing, which I think we all know that's a joke. That amounts, the decision's already made before you're allowed to speak as a victim. That's a fact, okay? So it has about as much bearing on it as, excuse me, but flying to the moon, okay?
Now, where do we go from here? Of course, we need y'all to continue to make noise and write state lawmakers in the next month to discourage them from electing Miller. And we need you to keep making noise about the Bowen Turner case. Bowen is out, and while we hope that he is rehabilitated, we want girls in South Carolina to be warned of his violent history. But the thing is, David Miller and Bowen Turner are just symptoms of a much larger problem. A system that favors those with power, money, and connections. A system where victims don't have a shot in the dark at justice because deals are being made ahead of time. A system where an elite few decide who the judges are and the rest of us are just at their mercy. I noticed on Miller's application he cited a 2014 bank robbery case where a man who drove the getaway car was sentenced to life in prison because it was his third felony. His two other felonies happened when he was just 15 years old. And this man didn't have the luxury of hiring a state senator attorney. Miller was proud of this case and used it as one of his 5 most significant litigated matters of his career. Miller decided that this case was worth fighting for and going to trial over, but not the rapes of multiple teenage girls. He didn't think they were worth fighting for. Is that really who South Carolina lawmakers want as their next judge? Is that the future we want for our justice system? We will be watching closely. Stay tuned, stay pesky, and stay in the sunlight.